This case looks small on paper, but don't let the dollar amount fool you. Because what unfolds in this courtroom is about far more than rent. It's about power, procedure, and what happens when rigid policies collide with real people. A mobile home park claims unpaid rent. A tenant insists she tried to pay and was blocked at every turn. The judge, already frustrated before the case even begins. And here, where things get interesting, we're not just dealing with numbers. We're dealing with alleged excessive late fees, rejected payments, disputed escrow orders, and a courtroom visibly reacting to behavior off camera. A viewer complaint becomes part of the record. A park representative gets her camera shut off. Attorneys clash over parte motions, contract law, and whether a landlord can legally refuse rent in a non-payment case. At the center of it all, less than $80. But that small number exposes a much bigger question. When does enforcing a lease become punitive, and when does procedure cross the line into unfairness? Stay with this case because every minute escalates, and by the end, you'll see how something as small as a late fee can grind an entire court to a halt.
Centerville Mobile Home Park versus Speech. Donna, she is present here with me at the court. Meg Bauer has filed an appearance on her behalf, and the counsel is here on behalf of the plaintiff from the Levine Swiss-Stack law firm. And we'll have you place your appearance on the record here. You're logged in as 30-day termination.
Yes, and I've been trying desperately to change that, Your Honor, without success. Daniel Landman, P35797, appearing on behalf of the plaintiff.
I'll change it. I want to address a little something before we begin. Your manager or owner, Mr. Senzo, is in the waiting room. I'll bring her in a minute. When she was here last time, I got an email from a viewer in November about how disrespectful and distracting she was at one of the previous hearings. And that particular person was outraged that she was smirking and laughing during the proceeding. And I thought I had forwarded that on to you, but I'm not sure that that was done. So anyway, we'll bring her in, and hopefully it isn't be an issue, or I can turn her camera off. But encourage me to play back the video. She's laughing and drinking water and making motions to other people, and that viewer felt she was very disrespectful.
This moment matters more than it seems. The judge isn't just talking about manners, she's asserting control over the courtroom. Viewer complaints making their way into judicial consideration is rare, and it immediately shifts the tone. When a judge acknowledges outside perception, it sends a clear message. This proceeding is being watched, and professionalism is not optional. What's striking here is that the judge openly admits she usually doesn't monitor on-screen behavior, but once it's brought to her attention, she acts decisively. That's not about punishment, it's about preserving the integrity of the court. And from this point forward, every reaction, every argument, every interruption carries extra weight. So here's a question for you. Should courtroom decorum extend to remote appearances in the same way it does in person? Or is this a new gray area courts are still learning to manage?
Respectful. We'll see. I often don't have time to see what's going on on the screen. All right. This is file number 252403LT, Centerville Mobile Home Park versus Donna Speech. It was a demand for non-payment of rent. Meg Bauer filed an appearance on behalf of the, what do you need?
Is Meg able to speak?
She said she was going to have to wait.
Okay.
So I told her to just stay in the room, and then when Meg is, this may take us a while, but I told her. All right.
All right, thank you.
We adjourned it. We've had several other cases with this park, and there are hidden costs that end up in the amount pled for that aren't often apparent. Miss Bauer had applied for an ex parte escrow order, I believe was granted. Her claim is that the calculation for the amount due is not accurate. So let's start at the beginning. Mr. Landsman, what's the claim to rearage at this point?
Your Honor, for purposes of this hearing, my client is claiming the following. Lot rent of $1,320, which is $440 a month for October, November, and December. Late charges of $120 total based on this court's policy of capping late fees at $40 a month. A meter fee in the total amount of $25.50. That's $8.50 a month for 3 months. Total water and sewer of $155.26 for the 3 months. That's $51.17 December, $53.33 November, $50.76 October. An administrative fee of $15 being $5 a month. Mobile home tax of total $9 being $3 a month, and a line maintenance fee of $15.
No, just slow down.
Sorry. Say when.
Mobile home tax, $9, 3 times 3. And what was the next?
And a line maintenance fee of $15, which is $5 a month for 3 months. That results in a grand total of $1,659.76.
And let's pause here because this is where most viewers get lost. The rent itself is straightforward, $440 a month, but layered on top of that are late fees, meter fees, administrative fees, taxes, and maintenance charges. Individually, they look minor. Collectively, they balloon the total. And notice something important. The judge immediately slows the attorney down. That's not accidental. Courts are cautious when fees pile up quickly, especially when tenants argue they attempted to pay. This is a classic landlord-tenant flashpoint, not whether money is owed, but whether the calculation is fair and transparent. Ask yourself this: if you tried to pay and your payment was rejected, should late fees keep accumulating? That question drives everything that follows.
And court costs are $170.05 for a total of $1,829.81.
All right.
And I'm gonna add something else, Your Honor, just unrelated to the dollars. I was very surprised to receive an ex parte motion to adjourn from counsel. Counsel was well aware that our office was involved in the case when she filed her appearance. I did not receive, and it is possible counsel reached out to Jarrett Levine, but I did not receive a request from counsel to stipulate to the adjournment. I think, as I understand motion practice, when there is an attorney on the other side, I believe it is inappropriate to make ex parte motions. I think the proper procedure, in my mind, should have been to reach out to our office first to see if we would have stipulated, and quite frankly, we would have as a courtesy. And then if in the absence of receiving the courtesy, then filing the motion and perhaps requesting a hearing before Your Honor. Certainly, Ms. Bauer being out of town was an appropriate excuse for an adjournment. We've I think adjourned cases from her office before by stipulation, and I was surprised that it was done on an ex parte basis, and to a degree even more surprised that the court considered it when the court was aware that there was counsel on the other side. If my understanding of the rules is incorrect, I will happily stand corrected.
No, I think your court rule is correct. There was an escrow in there. But Ms. Bauer, how do you address that? He is taken aback by your ex parte request to adjourn this and my willingness to grant it. I would not have granted it had there not been an escrow order in there, but what's your response?
Thank you, Your Honor. The adjournment request was less important than the escrow order. We were asking for that escrow order because my client has been unable to pay her rent, because the whole basis for this case originates out of plaintiff's unwillingness to accept anything less than $175 per month in late fees. In order to give my client a place to pay her rent so that she didn't lose it, we needed an escrow order so that it could be secured and so she could demonstrate her good faith. I have been in communication with plaintiff's firm about a previous case at this park, the Kloppenstein case, with no response. In an attempt they were refusing his redemption. I sent letters to Mr. Levine's office. And so in light of the fact that I needed an appearance in order to get the escrow order, but was going to be out of town, I had to also ask for the adjournment. Now, that said, this issue has been a repeated issue clogging your docket and being inappropriately addressed by this park, I think. And so we needed to get this in front of you so that we can get this resolved. Now, Mr. Landman has said today, for purposes of this hearing, we're going to charge $120, but that doesn't stop the fact that they are continuing to charge the tenants.
All right, well, you're getting an argument. The proper procedure would have been asked to adjourn it. You asked for the emergency. Certainly, they wouldn't object to an escrow order, I would think, but both you and me didn't clearly.
This is a procedural fault line. Ex parte motions, requests made without notifying the opposing party, are allowed only in limited circumstances. The plaintiff's attorney is clearly irritated and the judge acknowledges the rule wasn't strictly followed. But here's the nuance. The escrow order changed the equation. Escrow protects both sides. It preserves the tenant's good faith while ensuring money is secured. That's why the judge granted it despite procedural discomfort. This isn't favoritism, it's pragmatism. And it highlights something many viewers don't realize. Judges often balance strict rules against real-world consequences. So here's the engagement question. Would you rather a court strictly enforce procedure or bend slightly to prevent harm?
Strictly follow the rule here. For that, I apologize, Mr. Landsman. I'm sure you would have agreed to the adjournment. At any rate,
Your Honor, if I may,
at
at one point in time, I was known in Ms. Bauer's office as quote unquote the nice one from Swistak and Levine. That was due in no small part to the fact that my cousin used to work as a legal assistant in that office. So certainly I would like to think that I have dealt at all times, although adversarially, with individuals in that office respectfully.
All right, well, let's try to parse this out. The defendant's contention, both in the previous case and this case, is that the plaintiff wouldn't accept payment without their, and nobody allows $175 a month late fee, probably anywhere. And I think this is lot rent. There's a bunch of extra stuff in here, which isn't in the lease, which are little things. The $850 times 3, the sewer is certainly this administrative fee of $5 a month, mobile home tax, line fee. I don't know if those things are in the lease or not, but those may also be issues, but it's in the billing. It shows mobile home tax, administrative fee, meter fee, lot rent, so they were aware of it. But so let's talk about what we're at right now, Ms. Bauer and Ms. Speech. Lot rent $440 per month, October, November, December. Are we in agreement with that?
Yes.
All right. Late fees, 3 months at $40 per month. Now, defendant may claim she's not late because she's tried to pay October or at least November and December, and the plaintiff wouldn't accept it. What's your response to the late fees, Ms. Bauer?
Ms. Speech voluntarily or sua sponte attempted to pay a $50 late fee on October 17th. on top of the balance that they claimed she owed, and that payment too was rejected as below minimum. So we object to anything in excess of $50 in late fees. I do also want to put in here, we object to court costs because because she attempted to pay the entire balance through October plus a $50 late fee of her own that was prior to receiving advice from counsel on October 17th. And then subsequent to that, she attempted to pay all of the assessed charges, $440 in lot rent, the meter fee, admin fee, the tax, line maintenance fee. She attempted to pay all of that, plus the prior month, plus the $50 late fee on November 4th, which would not under the lease trigger any late fee provisions. So the only late fee that the defendant would consent to in order to seek resolution, perhaps, would be a late fee for October.
I can't tell from what I'm looking at how much I have in escrow. Maybe I can look in the electronic file. Can you tell me how many escrow payments you've made, Ms. Speech?
2.
So I have 886.
Judge,
I
you
paid
have
1,068 at first, and then I just paid December's before it was late, which was $514. So you have like 1,500 and something in escrow. All
Judge,
3 months.
1,068 was paid on November 21st, within a day or two of when the escrow order was entered, and then $512 on December 5th, according to the receipts I have, for a total of $1,580.
All right. Where does that bring us?
That brings me,
All right, we'll see.
Looks
Mr.
like there's a
Lansford?
difference of $79.76, Your Honor.
This is the heart of the tenant's defense. She didn't refuse to pay, she tried, multiple times. Payments were rejected for being below minimum, despite including rent and voluntary late fees. Once escrow was ordered, she complied immediately. From a legal standpoint, that matters. Escrow demonstrates good faith. It undermines the narrative of a tenant simply refusing responsibility. And when a court sees consistent attempts to pay, it starts asking tougher questions about whether penalties are being used as leverage rather than compensation. Put yourself in her shoes. If every attempt to pay gets blocked, how do you ever catch up? That tension fuels the judge's growing frustration.
Your Honor.
And that would be the $240 late fees that we dispute. And of course, Ms. Speech would have no notice of this sort of random imposition or decision on the number for the late fee, so she would have no way to account for that. But again, she wasn't late. As soon as the escrow, she attempted to pay on November 4th. It was rejected by their lease pay system. So we asked for the escrow.
Just a minute. Mr.
Yes, yes.
Senzo? Would you unmute your mic?
Hi, Your
I'm
Honor.
gonna blank your camera out. Viewers have contacted the court regarding your behavior on the screen. You're very animated about agreeing or disagreeing with what's going on. They felt you were very disrespectful to the court at the last hearing and were shocked that I didn't do anything about it. I wasn't paying attention, but you're doing that now. You're very animated with your approval or disapproval of what is being said. So I'm going to shut off your camera, but you'll be able to see us.
Understood.
And Your Honor, I will also jump in at this point and
All right.
indicate to whichever viewer or viewers felt that shaking one's head is disrespectful, I am happy to take it up with those viewers directly, and they may feel free to contact my office, because I am completely and utterly opposed to their position.
Well, Judge, I would like to take a point to say that I have actually had repeated concerns about the respect that this park has treated to my clients during these hearings. And for example, when Ms. DeCenzo's colleague shared his screen with my client's personal information on the YouTube.
This is a rare but telling moment. The judge doesn't just warn, she acts. Turning off the camera removes distraction while allowing participation. It's controlled, measured, and effective. What's important is why it happens. Not because of speech, but because of perceived reactions. Courts rely on neutrality. Visible approval or disapproval can undermine that, and once again, the judge prioritizes process over personalities. Ask yourself honestly, should emotional reactions be allowed when someone believes they're right, or does the courtroom demand total restraint?
The YouTube feed without your consent and over my objection. It is not just the viewers that have been concerned. But I'm not here to make ad hominem attacks. I'm just here to get this resolved.
Yes. There we go. All right. She can hear us, but she can make all the gestures she wants and nobody can see it. All right. So we're getting close to where we need to be. So, Mr. Landsman, what's your response?
Your Honor, the tenant, firstly, I disagree with the court that, quote unquote, no judge would allow $175 in late fees. I could list several judges across this state that have allowed that or more. If this court
right.
chooses to, have its own
Well,
cap, there are other
the law
courts
on
that have done
late
so.
fees isn't even clear. Some judges allow no late fees.
That's true. And some others have caps based on whatever their reasoning is,
so it's
and others
kind of the
allow
Wild
late
West,
fees
but I
in
didn't
full.
know anybody was allowing one that big. But maybe so. You practice all over. I'm just here in little Centerville. But yeah, the law on late fees, in fact, if you read it carefully, it doesn't even seem to allow it at all. But I've always allowed it, and I've let the number go up. But at any rate, fair enough.
And
But
what I will say is that this tenant agreed to late fees of $175 in the lease. The lease is a contract. The words of a contract are to be given their clear meaning pursuant to Rory versus Continental Insurance, which is the landmark Michigan Supreme Court case in that area. As far as my client's rejection of the payment that was not a payment in full, if it had accepted that payment pursuant to Park Forest of Blackman versus Smith, Court of Appeals decision from, I believe, 1983, my client would arguably have been prevented from filing this case. So therefore, it was justified, in my opinion, based on the prevailing case law, as I understand it, from it was entitled to reject the lesser payment. With that in mind, obviously, this court is entitled to make whatever ruling it wishes.
let me stop you before you go forward. This isn't a termination of tenancy case. It's a non-payment of rent case.
That's right.
And Park Forest doesn't apply to non-payment of rent cases. It applies to termination of tenancy cases. So if you file a termination of tenancy, you're right. You're not supposed to accept any payment after that. If it's filed as a demand for non-payment of rent, the defendant is entitled to tender rent and the plaintiff's supposed to accept it. But
I appreciate, Your Honor.
Here's the legal showdown. One side says the lease is a contract, period. The other argues a late fee that high is a penalty, not damages, and the judge cuts through it with something crucial. This is not a termination case. That distinction changes everything. By clarifying that non-payment cases require landlords to accept rent, the judge recenters the law around resolution, not escalation. It's a reminder that contracts don't exist in a vacuum. Courts interpret them through fairness, precedent, and purpose. So here's the big question. Should signing a contract lock you into terms forever, or should courts step in when enforcement becomes unreasonable?
Your Honor, this court's interpretation, again, we practice all over the state and other judges have taken a different position. So therefore, we advise our clients to
taken a position that Park Forest applies to non-payment of rent cases?
There have been rulings to that effect. We
Oh,
have
I've
not,
never
we don't like them, but there have been rulings to that effect.
All right, well, so what does that do for a tenant? Some judge in Sanilac ruled you can't make a payment on a non-payment of rent case. So here in Centerville, the landlord decides he's not gonna accept any rent. I've never even seen that before, and I just picked Sanilac out of the air. I'm not accusing the judge that may be there, but at any rate, we need to get to where we need to get to. So, all right. Enough of me venting.
Judge,
Go ahead. I cut you off.
Oh, no, I was just going to say that obviously we have to keep track as best we can of which judges are interpreting things which ways. And certainly I will note, and my office will note, that in your opinion, Park Forest doesn't apply in non-payment of rent cases, and we appreciate that input, and we will work accordingly with that.
I think I may have mentioned this before. We had a session a number of years ago when I first came to the bench on landlord-tenant law. And Craig Alston was the judge. He was the acknowledged landlord-tenant guru in the state of Michigan for district judges. There were more than 200 judges there, maybe more than 150 district judges. And he put these scenarios on the screen, and we would discuss these scenarios, and you get 8 different answers to the same question. And I remember thinking, isn't the law supposed to be more clear than this? And so I made a decision at that point, at least I'll do it the same way every time, so the lawyers will know what to expect. As you know, right now, there's a big dispute as to whether you can do a non-payment of rent case in a lot only mobile home case. Some judges have ruled that you cannot do it, and other judges like me allow it because it can benefit the defendant. So all I could say is I try to do it the same way every time so lawyers know what to expect, even though there may be some differences in how other courts do it. I think I'd mentioned a judge wrote a very learned opinion on why she does not allow it in her county. And I've read several briefs from law firms, I think including yours, on why it should be allowed, but we need more guidance. So we're not terribly far apart.
Judge, may I
yes?
address some of the points my colleague?
Well, I didn't let him finish what he was saying. Yeah, I keep cutting him off, so I'll let him finish and then I'll let you respond.
Thank you.
And I appreciate the court's consistency, and I think certainly when I've appeared before you, Your Honor, on these types of cases, you have been consistent. So as such, when we were scheduled for this morning, thus the reduction in the late fees to $40 a month in conformance with this court's policy. I'll yield the floor to Ms. Bauer.
All right, Ms. Bauer.
Thank you, Judge. To address the Park Forest issue, it is inconsequential in this matter. Plaintiff's complaint is dated October 20th. However, Ms. Speech attempted to tender the entire balance due plus the late fees, a total of $563 on October 17th, 3 days prior to the filing of this complaint. So Park Forest, even under Mr. Landman's interpretation, wouldn't apply until a case had started, but she had attempted to make her payments prior to this case starting. So regardless of the interpretation, that issue doesn't hold water. She attempted to pay them everything she owed. They still rejected it because she did not attempt to pay them a $175 late fee. So let me turn to that issue.
All right, well, let me stop you right there. Mr. Landsman argues she signed a contract that said she agreed to pay $175 a month.
That's exactly
and
what I was
me
going
or
to
you or somebody else said, well, hey, now granted, they should have accepted whatever she tendered, but the lease says that the late fee is $175 a month.
Judge, that was my next sentence. I said, so
All
on
right.
that, to that point, a contract clause for late fees is a liquidated damages clause. It is supposed to be a reasonable estimate of the actual damages that are otherwise hard to calculate. That the breaching party occurs as a result of the non-breaching party occurs as a result of the breach, right? That's liquidated damages sort of 101. However, a liquidated damages clause is unenforceable if that clause is a penalty. If it is not intended to recover or account for actual and estimable damages actually incurred. So we have two issues here. As I'll say, the defense's position is that, sure, that clause for $175 is in the contract, but it is a penalty, and therefore it is an invalid liquidated damages clause, and the court should not enforce it. I can provide a couple of citations, although Ramada Development Company versus United States Fidelity, and
Well, and I'm not proposing to enforce it. But so they, even under your client's position that they should have accepted her payment, it was not payment in full. If she unilaterally decides I don't have to pay the late fee, I hadn't made a ruling on the subject, the plaintiff still would have had a right to file this action, which they did, because there would have been at least some arrearage at that point, which so I would be inclined to allow the court costs.
the judge, by that argument, my client has to pay in order to defend
Just a minute,
herself.
Mr. Senzo has got her hand up. Mr. Senzo, you had a question?
Hi, Your Honor, yes. I just want to apologize. I am a very animated person. And I promise you it's not a sign of disrespect, more of a just upset that we're even here. We do, like, we don't want to be here, and we respect your time, and we did not want to come to court today. So in compliance with the last two rulings that you have given in this courtroom, we actually did change our late late fees, whatever the term you want to call them, in efforts of trying to do right by you and your judgment. On the 20th of November, we actually sent a notice to our tenants letting them know that we were going to be actually obliging with your $40 late fee recommendations. And we sent a notice to Donna on the 20th of November, literally stating that we want to remain in compliance with your recommendations and that we were dropping the late fees to $40 for all tenants. And she still chose not to pay in December.
All right, thank you.
I'll
all
state that at that point, the escrow order was already in place, and I do believe that had we not filed this motion in order request for ex parte order, this change would not have happened. We are glad to hear of this change. But I don't believe it would have happened had we not had to file, or had we not filed.
May I speak?
Yeah, I let her speak.
On November 4th,
Now you have to speak up.
on November 4th, I did try to make my payment for November and October's with $50 late fee instead of a $40 late fee, and they locked me out. For 6 weeks, I tried to make my payment.
Yeah, that's your attorney's already represented that.
So I just wanted to respond because she's saying November 20th. Well, how come you didn't let me pay it on November 4th then? And after that, it was done. The escrow order was in.
All right, we are very far apart.
So I let my lawyer do the rest, and they kept harassing
fair
me.
enough.
So
All right, so plaintiff's claim right now is for $1,659.76. And that's through December with a $40 late fee and the other related fees. Defendant has paid to this point into escrow $1,580. Which is, as Mr. Landsman said, $79.76 a part. And as Ms. DeCenzo says, she didn't want to be here. I think it's unanimous. None of us wanted to be here, but here we are fighting about $79.76. But as Ms. Bauer said, these challenges have led the park to changing some policies and procedures, and they're new owners and they're learning our procedures. So maybe there's some benefit from this. The other issue is the filing fee of $170.05 that defendant objects to. And I didn't make a ruling, but I indicated my inclination is to allow the court costs. So that would be $79.76 minus $170.05. $249.81 would be the total through December. All right, Ms. Bauer, do you wish to again make your argument as to why there should not be any court costs?
I do. I'm looking for the citation right now. There is a portion of the Summary Proceedings Act that suggests that the court should take into account whether or not to award the fees based on whether there is any mitigation in the amount demanded. I believe it is 600.5741. In determining the amount, yeah, it is that section. And had
600.5701.
5741.
All
In
right.
determining the amount due under a tenancy, the jury or judge shall deduct any portion of the rent which the jury or judge finds to be excused by the breach. The statement in the judgment shall be the judgment. All right, I'm sorry, Judge, that is not the right citation. This being a first hearing, I didn't realize we were going to be litigating it this far today.
Yeah, there is that. This is just the first hearing. I was hopeful we could get to the finish line today.
If the plaintiff fails to prosecute his complaint, or if upon trial or motion the plaintiff is found not entitled to possession of the premises, judgment shall be rendered for the defendant for his costs, which shall be taxed and collected in the same manner as other civil judgments. So MCL 600.57.47. The only thing litigated here, the only damages the plaintiff was seeking is those $175. Had we not filed this motion, had we not asked the court for an injunctive order preventing the park from assessing these fees in the future, this change wouldn't have happened. So to award the plaintiff its costs is to reward them for filing these actions and to penalize Miss Speech for defending her case. And we have not asked for my costs and fees in this case. Although we could.
Your Honor, the motion for the ex parte escrow order requesting injunctive relief, I think, was horribly overbroad. An escrow order can be entered without an injunction. This court never granted the injunctive relief requested by Ms. Bauer, and it would have been wholly inappropriate to do so without holding a hearing with notice and an opportunity for response from all parties. She could have requested perhaps a temporary restraining order with later an injunctive hearing. She did not attach an affidavit or any other item that would have persuaded this court that her client was suffering irreparable harm. So I think to argue at this time that this court granted injunctive relief, quite frankly, probably the appropriate remedy would have been filing a separate lawsuit in perhaps circuit court and asking for equitable relief. But I think to argue today that somehow this court granted her an injunction and therefore she's the prevailing party, I think is wholly misplaced and flat out wrong.
Judge, that's not what I'm arguing.
I thought all I granted was the escrow.
That's correct. That is
But,
all you granted. And I'm not arguing that we prevailed on that. Also, plaintiff didn't file a response to my motion, which they were.
It was an
fully
ex
free-
parte motion, Your Honor. It wasn't scheduled for
Yes.
hearing.
No, that doesn't, there's the motion rules for filing a response, the timings still apply. The point is, we're not that we prevailed on that request. The point is that we prevailed on getting the late fees mitigated, potentially. You haven't made a ruling yet,
Well,
Judge.
you did just now. I didn't even make a ruling. They just capitulated and agreed to move it to $40. I didn't make a court order or a court ruling. They just agreed to it. My opinion is they're entitled to their costs. We're going to set a second hearing and you guys can think about it in the meantime, which would mean through December, the defendant would owe $1,659.76, offset by $1,580 that's presently in escrow, leaving a shortfall of $79.76.
Judge, you're intending to award them late fees for November and December, despite my clients paying within days of the escrow order and paying on the escrow order on December 5th?
Because it's not late until after the 5th. And I was not late for November.
Yeah, that's a legitimate point. I don't want to fight about this anymore. I'm going to kick this can down the road. I resent spending an hour and a half to fight about $80, but we'll have to try to be accurate. Even it is a small amount. You're trying to make your point.
Attorney Landman could have called me also. This is the first I'm hearing of the concession.
The first I'm hearing of it as well.
Oh my goodness.
All right. December 29th is quite full, but in for a penny, in for a pound.
I'm going to start using that at our case review decisions, Judge.
Yes, well. Yeesh. That's the first day back after the holiday and it's already crammed full of stuff. We're going to continue this. And again, every time we continue it, it's an additional cost to the plaintiff. Defendant doesn't pay cost for her services. Ms. Bauer argued that perhaps there should be an assessment of their costs. But maybe the parties can just agree, can agree to settle on a figure, in which case neither party would need to appear. But I'm going to continue this to
Judge,
12/29/25 at 2:45. Yes?
Although we are a nonprofit law firm, we do still incur costs, and we are authorized by statute and by our regulations to request costs and fees. We just simply don't do that very often because it tends to harm our clients more than help.
Yes.
Your Honor, they're only entitled
I'm not
to
insinuating
costs.
you didn't incur any costs, but your client didn't. Now, she's well represented here, and you're fortunate to have competent representation.
Yeah, I'm very lucky. And I really appreciate
As I indicated, they're new to this park, they're new to this business. They're well represented. Also, Jared Levine practices landlord-tenant law all over the state. That law firm does. Mr. Landsman's been around and he's done a good job for his clients in the past. And sometimes we need to fight it out a little bit to get to a place where everybody knows where to go moving forward. So I think we're getting there, but we're fighting about not very much money. I would like to resolve this in December because I don't want to do another escrow payment in January.
Thank you.
I'd like you to just pay your rent to your landlord. But we're not very far apart. Ms. Bauer contends, perhaps with merit, there should not be a late fee for November or December because she attempted to tender the rent and the plaintiff wouldn't accept it. So in essence, we're fighting about $80. Well, we're actually fighting about 24 cents.
$140.
If I took the 2 late fees out, the arrearage would be a 4-cent credit. I would allow the attorney fees and the costs. So if I grant $80, you'd have a 4-cent credit toward January's rent. And I would allow the court costs of $170.05. So that's where we are. Not 4-cent, a 24-cent credit. All right. I don't know if you guys are in a position where you wish to speak to each other at some point further, but I'd encourage that. We'll come up with some sort of a ruling on December 29th. All right. Thank you all. Mr. Senzo, thank you for your input as well.
Thank you, Your Honor, and I will wish the happiest of holidays to the court and its staff, to Sister Counsel, and to her client.
All right. Thank you all.
Thank you, Judge. Miss Speech will be in
All
touch.
right. Miss Brewster is still in the waiting room, Meg.
All righty.
Miss Speech, you're good to go.
At the end of nearly an hour and a half, this case comes down to less than $80 and a lot of legal principles. The judge acknowledges procedural missteps, recognizes good faith payment attempts, and openly questions excessive fees. No final ruling today, but clear guidance moving forward. What matters most isn't who won. It's that policies changed, scrutiny increased, and fairness was put back at the center of the discussion. This case shows how small disputes can expose systemic issues and why courtroom transparency matters. If you found this case as shocking as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.